Hello everyone, welcome to the 160 Q&A practice. We're going to start out with plaintiff questioning. Ready? Your son was attending Fairgrove Middle School? That's right. The first time that he ever had a class with Mr. Vanderment was in the fall? I believe so. What grade was he in at the time? He was in 8th grade. Had you known Mr. Vanderment prior to the time your son was taking his class? No. Had you heard anything about him at all? Not until after my boy was struck. Up until that time, had you never heard anything good or bad about Mr. Vanderment? No. When did you first learn about your son being struck by Mr. Vanderment? It was around the middle of February, more or less. The middle of February, you say? Yes. Was that at your home? Yes, sir, it was. Just how did you learn about it? He told me. Your son told you? Yes, sir. What was the nature of the conversation with your boy when you first learned of the incident? Well, he would come home complaining every day about his legs and about his dizzy spells and about the cramping of his legs and not able to sit down. It was the same thing every day. How long had this been going on? Since September? This was in February when he told me this. About how long had he been complaining of it before you asked him about it? About a week. Prior to that, had he ever complained about it? He would complain, but he wouldn't tell me what was the matter with him. When did he start complaining about dizzy spells and his legs hurting? Along in September. September? Right after school started. That continued up until February? Yes. During that period of time, were you asking him what caused it to hurt? Well, I would ask him how it hurt, but my sister told me she thought they were growing pains in his legs. I just figured he would be over it one day. Did you ask him if he had fallen and hurt himself in any way? Yes, I did. What did he say? He said he hadn't fallen. Had you questioned him several times about it? Yes. But he never said anything about being hurt until February? Not until February when he really got sick. In February, did he appear to be worse? Yes, very much. Did he limp? Yes. Was it quite a noticeable limp when he would walk? Very much, yes. He could not walk the same. Did it appear he had to catch onto things because of his dizzy spells, or did you notice he would almost fall? Yes, he acted as though he was kind of dumb, kind of clumsy, like he wasn't himself. He kind of staggered when he walked? Yes, and he dragged his feet to walk. He dragged both feet? Yes. Did you notice anything else? He would trip real easy. Trip real easily? Yes, sir, and bump into things as he was walking. All right, so I'm going to switch transcripts. This is going to be plaintiff questioning as well. Mr. Blake, you are one of the defendants in this case? Yes, sir. You and the defendant Rick Darwin are engaged in the sand and gravel business. Is that right? Yes, we are. Are you in the business under the firm name of Birmingham Sand and Gravel Company? Yes, that is right. Is that a partnership? Yes, it is. Mr. Blake, at the present time, are you digging a conglomerate mass of rock, sand, and silt out of the side of a hill to the west of the property located on Lot 12, Tract 8340 in Smith, Alabama? Yes, at the present time, that is exactly what we are doing. Is this conglomerate mass loaded into trucks? Yes, it is. Then it is transferred to a conveyor belt, which takes it to a washer. Am I correct? Not exactly. The conveyor belt carries the material to a screening plant. Is it necessary for this screening plant to use water? No, it is not always necessary to use water, but we do occasionally. What is the source of the water? There are 2 wells on our premises which are northwest of the plant. How does the water get to the screening plant? It is pumped from the reservoir. Is that the reservoir that is in the diagram? Yes, that is the one. Does the water then pass through the screening plant? Yes, it does. What happens next? The screening plant separates the sand from the conglomerate mass of silt and dirt. Please elaborate on that. When the material reaches our screening plant, it is then separated in 5 different sizes and dropped on various conveyor belts and taken away in the sizes that we desire. How many sizes are there? 5 different sizes. What is the final size? That would be the sand. Now tell me, after the water leaves the screening plant, is it clear or unclear? Well, practically clear water, yes. It would depend on the type of material we were screening at that time. After this screening process, when you separate these 5 sizes you have told us about, is there dirt left? Yes or no? I have to explain to you. Is your answer no? No, there is no dirt left. We try to retain every bit of the material. We retain everything possible that goes through that plant, because what you refer to as dirt is our fine material, which we ultimately try to use. I am not talking about what you try to do. Where does the 1/6 dirt part go to? It isn't 1/6. There is less than 2% of the total material that is left at any time. Then there is very little of this material left suspended in the water that comes out of the machine. Is that right? That is correct. Where is the water transferred to after this? The water leaves the machine or screening machine and is piped to an inlet to a basin at the easterly end of the property. When the water enters the basin, is it comparatively clear? Yes, it is. What happens to the water in the basin? We put a special suction type device with a large shovel on the end to remove it. Isn't it true that several times this basin has overflowed into the neighboring property because of your company having failed to remove the sediment buildup? Not to my knowledge. Isn't it true that the pressure caused by the sediment buildup caused the basin to have underground seepage into the neighboring property and onto the adjacent highway? No, that is definitely not true. Okay, so I'm going to switch transcripts. All right, this is going to be the court. Start out with the court. Matter of netter and netter. Appearances for the record, please. Yes, Your Honor. William Anderson on behalf of the petitioner who's present in court. Marla Hendrickson of Norman Filler's office for respondent Cindy Netter. She's present. All right, counsel. I indicated to you in chambers yesterday I could give you between 9 and 10 this morning. It's now 7 after 9, so we have between now and 10 o'clock. We discussed some of the trial issues yesterday, and Mr. Anderson, you are the petitioner. Would you like to outline the trial issues from your standpoint? Well, Your Honor, I think it's the custody and visitation order that was made. All right, let's not talk about custody and visitation right now. Let's talk about factual trial issues. We have the issue of the $120,000 check from the petitioner's parents to the parties. There's the issue. $120,000 loan issue. What else? There's the issue of the ownership of the jacuzzi and whether or not there's any amount owed to the respondent's mother. Ownership of it's a portable spa, correct? Correct. We have the support issue. Support, all right. Spousal, we have attorney's fees. We were able to make headway on dividing some of the personal property. There are several items left as there's a dispute as to characterization and possession. I mentioned attorney's fees and costs. Yes, there's an issue as to the characterization of the 2009 Ford Escort. There are Epstein credits requested of the petitioner anyway. The house, I think we agree, needs to be sold. How the proceeds need to be distributed was another issue. I believe that Ms. Hendrickson, do you agree with the particular trial issues? Yes, Your Honor, we do think there's an additional issue, though, as to the fair rental value of the house, which Mr. Netter has resided continuously in since the separation in October of 2015. I thought you agreed to that yesterday in chambers. No, Your Honor, we did not agree to that. We indicated there was what do you think a fair rental value is? We believe the fair rental value is $1,950 a month, and he is Mr. Anderson. We believe it's $1,850, and we would agree to $1,900. Ms. Hendrickson, $1,900? Yes, for the purposes of resolution. The court finds the reasonable rental value to be $1,900. Any other trial issues, Ms. Hendrickson? There's an issue of spousal support, Your Honor. He's already mentioned that. Mr. Anderson has outlined what he feels the trial issues are. My question to you is, are these the trial issues? Are there more or less? That appears to be the extent of the issues at this time. Good. All right. Let's start with issue number 1. The issue concerning the loan. Mr. Anderson? All right, so we'll stop there, and that concludes our Q&A practice for the 160 class.